Was the case called? I'm sorry, I didn't hear it.
Yeah, I called it. Now, Ms. Savona just showed up.
Good morning.
Okay. Ms. Hayes, you're up.
Yes, good morning, Your Honors. May it please the court. I represent the appellant in this case, which is TMH Medical Services. And the issue before the court is whether TMH's case for negligence, breach of contract, FDUPTA, declaratory judgment, third-party spoliation of evidence, and other claims is res judicata or collateral estoppel or subject to issue preclusion based on the federal court coverage litigation that preceded the state court case that we're here to discuss.
Ms. Hayes, in the federal case, am I correct that the federal court concluded as a matter of fact, that there was no relationship between your client and the PEO when the employment claims arose?
No, Your Honor, they didn't. The federal court never determined whether there was a relationship at that time or what the relationship was. The federal court merely determined that the agreement that was signed did not meet the requirements of Chapter 468 of the Florida statutes, which govern PEO service agreements. And therefore, because it did not meet that statute, there was no coverage under the policy, which provided coverage for PEO client companies of the appellees. So there was no, in fact, the court in the 11th Circuit opinion that was written states, regardless of what other PEO services are contained in that agreement. So it finds that there's an agreement and the agreement includes PEO services, but it doesn't meet the requirements for a PEO service agreement under Chapter 468 of the Florida statutes. And that is actually one of the key bases for the reason for the state court case. I mean, it was filed based on the PEO's failure, in part, filed based on the PEO's failure to provide an appropriate PEO service agreement at the commencement of the services that were provided to TMH.
And if to follow up with that, Ms. Hayes, as I understand it, at least back in the federal court, what was before them, they made a determination whether or not there was at least as I see the order here, whether or not there's been an agreement. I mean, whether that contract was in place. And correct me if I'm wrong, in the trial court, didn't the order also, I mean, in the trial court, wasn't the prior federal case was incorporated in its amended complaint? And the main reason I'm asking that is that it comes down to, okay, was there an agreement? Was not agreement? We have the date of the incident. We have an issue as to whether or not the agreement was entered after the claim or a claim was made. And so we're dealing with that issue. So I guess my question is, if the amended complaint incorporated the prior federal case, and if the prior federal case came to the conclusion that the agreement really there was no such agreement, isn't the state court bound by that determination?
Yes and no. The state court is bound by the determination that there was not a PEO service agreement. And I'm doing air quotes here because the statute, the policy of insurance said a PEO service agreement between the parties. It didn't say that it had to be signed. It didn't have other details of what was going to be in that PEO service agreement. The policy of insurance just said that anybody with a PEO service agreement was entitled to coverage as a client company under the policy. So the appellate court and district court in the federal case found, well, there's not a PEO service agreement for the reason that the contract signed between the parties didn't meet Chapter 468. And that is the extent of the finding. The court declines to decide whether the PEO service whether the agreement that was signed between the parties, the 11th Circuit expressly declined to decide whether it was in effect or not in effect on February 23rd, 2017, when the claims were first reported, or on April 12th, 2017, when client company claims were first made. It declines to make that determination, and it just says at TMH at no time was subject to a proper quote PEO service agreement, which was what the policy provided. But the 11th Circuit, as I said, does acknowledge that the contract that was signed included PEO services. It just didn't follow Chapter 468 of the Florida statutes, which imposes a duty on PEO companies to have, before their first service is provided, to have a written PEO service agreement with anybody that's a PEO client company. So that is imposed on them, and under FDUCTA, that's violation of that statute by a PEO is a per se violation and constitutes grounds for a FDUCTA claim, and that's written right into the FDUCTA statute. So that Chapter 468 is something that was supposed to be provided. And you asked, was it incorporated in the amended complaint? So let me discuss that. In the record at page 564 to 565 there's 2 paragraphs in the amended complaint, and they're cited also in the answer brief, paragraph 44 and paragraph 45. And paragraph 44 says that the federal court found that the agreement they provided did not meet the requirements of a PEO service agreement, as I've just told you, which is one of the bases, as I said. Their failure to meet 468 is one of the bases for our.
As a matter of statute, would a service agreement necessarily include an ELPI coverage?
No, sir. I don't believe that that's in the statute, that it has to include EPLI. But it was, as the record reflects, TMH was signed up by a gentleman by the name of David Curry, who was an investor in the Platinum Sinuity Group, and was told and was furnished a brochure that included EPLI. And EPLI is an important component of PEO relationships. It's one of the hallmarks of the PEO relationship, according to the case law, including reporting of the client company's employee wages for unemployment taxes and for federal income tax purposes under the employer identification number, like on the 941 forms that are filed. That's what a PEO does. It reports those wages as if it were its own employer. And all of those things were happening in regard to the TMH Sinuity relationship. Sinuity just forgot to get an agreement in place for my client until after they heard about these claims, at which time Sinuity, as the record reflects, prepared an agreement, sent an agreement, and asked that it be signed today. And in response to that, I, representing TMH, said, well, you're asking for an agreement for EPLI. We didn't instigate the agreement after the fact. They did. I said, you're asking for an agreement for EPLI. And as the email reflects, I said, we need to include it in there. And I redlined the contract, and they responded back, approved. And that was the only guy that could sign a contract for the PEO, because you have to have a controlling person under the statute. And that's the only person that can assign a contract. And so, based on that, my involvement was the subject of their 2 motions to disqualify, one of which in federal court was found to be meritless. And then the same identical one filed in the state court, which they never set for hearing. And, I think the courts probably reviewed the record, 2 bar grievances against me, which were both dismissed with no probable cause, one by a judge that is friends with one of the owners of this company. So all of those things have proceeded where we are today, which is we ended up with this dismissal order. Respectfully, there's really no basis for it. Paragraph 44 and 45 simply state the truth, which is the federal court found that they didn't meet the statute. We don't incorporate the coverage claim into our suit for negligence. And there's many times when a coverage case is independent of a suit for negligence. And the fact of the matter is, and this is in the record, that TMH did not know that Platinum was going to take the position that it never had a PEO relationship with TMH until after the coverage suit was filed. And TMH did not know that Platinum had changed the date on TMH's signature and backdated its own signature when it presented the PEO service agreement that was not a PEO service agreement to the insurance company. That was all done by Platinum and wasn't known to TMH until 10 months after TMH filed the coverage case. So they argue, collateral estoppel, you could have sued us when you sued the insurance company. TMH did not know that Platinum had engaged in that activity until March of 2018, when National Union produced to TMH a copy of the backdated agreement. I'm sorry, when it was produced sooner than that, but it wasn't until March of 2018 that Newfic and TMH realized that there was a problem with the date on the agreement, and that the date was different than the date that was shown on TMH's agreement. That was not known until 10 months after the lawsuit was filed. So if you apply their rule, every time that there would be a coverage case, if someone didn't have insurance coverage, you would end up that you couldn't have a negligence claim against the underlying party that was negligent and in the case. And it just, these are two completely different cases. There's no common remedy sought. That case sought insurance coverage, and Newfic paid for the defense of TMH. So the policy responded with defense of TMH, not initially, but after the suit was filed. But the indemnity obligation was not met. And so we, in good faith, sued under the policy with Sinuity's support and Tom Newman's statement that you're a client company and you're entitled to this coverage. So we went forward with the coverage case. The tune changed, and that's what paragraph 45 says. That's the second paragraph that refers to the federal court case. It says, according to the new version of history in testimony offered in the AIG case by Platinum HR, the relationship was not a PEO relationship, but a staffing relationship consisting of payroll processing services only. That's the paragraph they rely on to say that paragraph makes our claims in this case res judicata based on a determination in the federal case. It's really it's such an unsupported argument by fact and by law. Yes, we do rely on what the federal court case found, and we rely on it because the federal court case supports our claims that Platinum was negligent. And if you don't have any other questions for me, I would reserve the rest of my time for rebuttal.
Thank you, Ms. Hayes. Ms. Savona?
Thank you, Your Honor. Good morning. May it please the court. Therese Savona on behalf of the appellees. This court should affirm the trial court's final order on dismissal. And I want to start my argument touching on the two questions that were asked by the panel of my colleague. Judge LaRose, you asked about whether the federal court, as a matter of fact, was there no relationship. This is specifically in TMH1, which is the Middle District's order on federal, on the defendant's motion for summary judgment, specifically at pages 935 and 936 of the record. It says, although the service agreement discusses the provision of services that are typical of those provided in a PEO relationship, it fails to actually establish a PEO relationship. Again, on page 936, the Middle District concluded, with these deficiencies, the service agreement cannot create a valid PEO relationship or constitute a written PEO service agreement that passes muster under the policy or Florida law. So I hope that answers your question. Judge Kuzam, you pointed to the amended complaint, specifically to the paragraphs 44 and 45, where TMH had referenced the federal allegations in the federal case. If there are things that are apparent on a complaint, such as a res judicata defense or a collateral estoppel offense, those are defenses that are available on a motion to dismiss, and those were raised by appellees because in paragraphs 44 and 45, TMH discusses the litigation under the policy. And yes, it does state the policy. However, this references the federal litigation, and as apparent in the record and in the briefings, the federal case, the facts have all been discussed and have been incorporated into the record on appeal. I would also like to remind this court, this case is here on a motion to dismiss. not on a motion for summary judgment. So this court looks at the four corners and considers what is on the face of the complaint. One thing that my co-counsel mentioned said that the remedy in this case is not the same. I would like to point that at the motion for reconsideration hearing, TMH admitted to the successor judge that the damages in this case were the same damages in the federal case, and that's at record 2336. And I quote, "In this case, we're seeking the same damages. If we had insurance coverage for our claim, we wouldn't be seeking the damages again in this case." So to say that the remedy is different, I don't think that is correct based on what was argued to the successor judge at the motion for reconsideration. My colleague has also argued that they learned of issues during the discovery in the federal case, and they said that they weren't aware of that position. I'm sure that TMH could have amended their complaint in the federal action at that time if they learned of information that led them to different causes of action. And unless this panel has any questions for me, I would respectfully request this court to affirm the trial court's order of dismissal, and I would rely on my answer brief.
Okay, Ms. Hayes, you had about 7 minutes to go when you stopped, so I'll let you have that for rebuttal.
Yes, thank you, Your Honor. Once again, the 11th Circuit agreement, the 11th Circuit opinion actually states that there's PEO services included in that contract. So there's not been a finding one way or the other that as to when the contract was entered into, which was one of the questions I was asked, was it before or after those claims? The court declined, it specifically declined to find that. And the contract—
Does that necessarily dismiss the summary judgment findings made by the district court?
I'm sorry, I'm not sure I understand
Well,
what you're—
the question that you're telling me the 11th Circuit addressed was that this was not a valid PEO agreement.
Yes.
Okay, and that's the extent of its holding. To what extent can Platinum still point to the factual findings made by the district court
Well,
about the existence of a relationship?
Well, I think that if the district court said the agreement wasn't sufficient to establish that there was a PEO relationship, that stands. I mean, the appellate court affirmed the district court, but the appellate court didn't specifically make any mention of the relationship between the parties, and that's what I was referring to. And even if there's not a PEO relationship between the parties, that doesn't mean that our claims are barred by res judicata and collateral estoppel. We're still entitled to bring claims for negligence on the part of the PEO who was responsible for signing and onboarding TMH in the way that was required by the statute, was responsible for having its employees sign acknowledgements, which is in Chapter 468 of the relationship. These are the things that the 11th Circuit found were not done. And none of those duties was TMH's duty. All of those duties was the PEO, who is the expert and is required by statute to basically have a license holder, a controlling person, who Mr. Tom Newman testified in his deposition testimony in the record that he's an expert in PEO, that he knows all about it. And he was the controlling person responsible for securing an appropriate agreement. We also have claims in this case that were not even the subject of the motion to dismiss, that were dismissed with prejudice. The motion to dismiss takes a finding, a determination that there was no proper PEO contract for coverage purposes, and it decides that all counts of the complaint, all 11 counts of the complaint, are dismissed with prejudice on the basis of the coverage opinion. That includes counts, as I said, count 1 is professional negligence against Tom Newman. They didn't even move to dismiss that on the basis of res judicata. Count 2 is negligence for Platinum HR, the PEO company. Count 3 is negligence for Platinum XL, the staffing company. Count 4 is Fiducta. Those 3 counts, they moved to dismiss for res judicata purposes. Count 5 is negligence per se, which is expressly authorized by Florida Statute Chapter 468 and the Florida Administrative Code, which imposes the obligations on the PEO. Count 6 is.
Well, Ms. Hayes, I understand the theories may be different, but I think we need to scour the 11th opinion decision and the district court opinion to figure out what issues are now precluded, what factual issues are precluded.
Well, I would point you, Your Honor, to the record, and I would specifically point you to the 1344 to 1483, which are our requests for admissions that were deemed admitted, because those go through and admit all of the critical facts in support of our claim that were not refuted or denied by the appellees. And many of those facts come from the findings in the federal court case. So these claims are entirely consistent with what the federal court found. You know, Your Honor, Judge LaRose, you wrote the opinion in the 41 Yellow case, and it's entirely different than this. I understand that because it was the mortgage foreclosures. But in that case, you lay out what are the requirements for res judicata and collateral estoppel. The identity in the thing sued for. Coverage, yes. Does the coverage include damages? Absolutely. Versus damages for negligence. Spoliation of evidence is a third-party claim. How is that barred by the federal court case? That was the case where the spoliation of evidence occurred because Platinum, as a witness, withheld, destroyed, lost, pretended it didn't have computer records and other evidence that supported our position concerning this PEO relationship. So that's a claim. How could that be barred by res judicata? And
Well, I'm not sure that your citation to the case I authored deals with issue preclusion.
And neither did their motion to dismiss in the state court. They never argued issue preclusion until the appeal, as I pointed out in the reply brief. But one thing that the case says is your case, 1 Yellow, is the particular matter must be fully litigated and determined in a contest resulting in a final decision of a court of competent jurisdiction. If the agreement failed to make a PEO relationship, that is a negligence claim because they were responsible for having such an agreement and they clearly provided PEO services in the form of reporting our taxes. They gave us brochure that said that we had EPLI. Platinum itself took the claims when we reported them and gave them to AIG and said, these should be covered. In the record are emails written by Michael Zaritsky, one of the owners and an attorney for Platinum, where he says, the form of the agreement was messed up, but they were intended to be in a PEO relationship. He actually says that to AIG in reporting the claims. So, these are matters that have not been litigated. Our rights and our claim for damages against them for their negligent onboarding of TMH has not been litigated. And there's no way there has been a determination in a contest resulting in a final decision of a court of competent jurisdiction.
Hey, Ms. Hayes, that's your time's up. So thank you very much. Thank you, Ms. Savona. In order to leave our virtual courtroom, you need to click the leave button of all things.